Hello everyone and welcome to this video tutorial in which we're going to be doing some A-level law revision for contract law. And in this video we're going to be doing a whistle-stop tour of all the key topics that you need to know really well for your contract law exam. And we're going to go through each topic and look at some of the key concepts, the key cases that you need to know. And I'll also try and weave in some exam tips of the sorts of questions you're likely to get asked for each topic. So let's make a start then with our first topic in contract law, rules and theory of contract. Rules and theory of contract law, if it comes up, it's likely to come up as an evaluative essay where you get asked a question such as, discuss whether there's freedom of contract in English law. And this topic needs you to understand the basic rules and background, why contract law came about. And you need to be able to talk about the fact that the law of contract is a civil area of law which is regulating the creation and performance of contractual obligations between parties. And a definition of contract is a promise or a set of promises which the law will enforce. And contract law developed during the Industrial Revolution, and it's useful to list the elements of a contract: offer and acceptance, consideration, intention to create legally binding relations. Now, whilst the law of contract largely originated through the common law, there are now significant aspects that are subject to statute, and you'll be familiar with some of those, like the Consumer Rights Act. Evaluative question, you might be asked to justify the law on contract law because, unlike other areas of law like criminal, say, the law of contract isn't concerned with punishment, but it's all about trying to ensure that contracting parties retain freedom of contract and are able to enter into contractual negotiation. And you could justify it on the economic ground there. I've given you a definition from Roscoe Pound, or also on the moral ground to right the injustice of non-performance. And you could talk about classical and neoclassical theory here. Classical theory is freedom and sanctity of contract, i.e. that courts are reluctant to intervene in a contract between private parties. But neoclassical theory, the courts do want to try and ensure fairness, particularly where you've got an imbalance of power between the two contracting parties. So that's the background, if you like. Let's start looking at the other topics in contract law. So offer and acceptance is a really big topic because there's a lot of case law here. And offer and acceptance could come up in two ways. It could be an evaluative type essay where you might get asked something like, discuss whether it's easy to establish whether an offer and acceptance has occurred in a contract. Or you could get a scenario where you're given a bunch of facts and you have to discuss whether an enforceable contract was made or not. So you would need to know all the rules on offer and all the rules on acceptance, and I've just summarised them there for you. But an offer is a statement of willingness by the offeree to enter into a legally binding contract. And key things to remember is distinguishing between an invitation to treat and not an offer, that a statement of price is not an offer, and that it must be communicated. And you could talk about the postal rule for acceptance is sort of often tied in there with this communication. And that's something to look out for in a scenario. Quite often you've got a number of characters in your scenario and one of them tries to accept an offer by post. And of course, that's wanting you to talk about the classic case of Adams and Lindsell there. Also need to know all about acceptance and the fact that acceptance must be unconditional. And if the person tries to alter the contract in any way, that's going to make it a counter offer. And it kills, if you like, the original offer. And you've got to look at different requests. Requests for further information are not going to be offers. The acceptance must be communicated, and also more modern issues, I suppose, if you like, specific forms of acceptance where the person says you've got to accept in this particular way, battles of the forms, where two businesses are trying to negotiate on their own specific terms, and modern methods of communication, the issues of emails, and what's the rule on those. And I've just listed some key cases that I'm sure you'll be familiar with there. Next topic is consideration. And consideration, you can see I've given you a definition at the top. This is the price given in exchange for goods or services under a contract, either a detriment incurred by the person making the promise or a benefit received by the other person. And to summarise this topic, it's really crucial that you know these 5 rules of consideration. So consideration must be sufficient but need not be adequate. So as long as something's given in exchange, it could just be a penny, it could potentially be a chocolate bar wrapper, that can still amount to consideration. The consideration must move from the promisee, and that comes from the classic case of Tweddle and Atkinson. And an existing contractual duty doesn't constitute consideration, Collins and Godfrey, Williams and Roffey. Part payment of a debt is not consideration, Pinnell's case, but remember, as we so often do in law, there are a couple of exceptions to this rule. If there's been part payment by a third party, or if promissory estoppel occurs, and of course we've got Lord Denning to thank for that from the case of High Trees. And the consideration must not be passed, re McArdle and re Casey's patent. Remember, consideration could be an evaluation or a scenario type question, and I do have separate videos on my channel as to how you would apply this to a scenario, so have a look at that if you need help with that. The next topic is quite straightforward, intention to create legal relations. The requirement of intention to create legal relations in contract law is really aimed at sifting out those cases which aren't really appropriate for court action, because not every agreement that you make in your day-to-day life leads to a binding contract which can or should be enforced through the courts. So in order to determine which agreements are legally binding and do have an intention to create legal relations, the law draws a distinction between social and domestic agreements and agreements made in a commercial context. You would expect with a commercial agreement there is a strong presumption that there's an intention to be legally bound by the agreement. And some key cases you've probably looked at here are Esso, Jones and Confetti Records. However, in social and domestic agreements, the law raises a presumption that generally parties do not intend to create legal relations, and that comes from the case of Jones and Padavatin. But there are exceptions to that rule, and you need to look at some other key cases on that. Balfour and Balfour, Merritt and Merritt, Wilson and Burnett, Simpkins and Pays are all really nice ones to look at, because sometimes a social or domestic agreement can become a legally binding contract, if there's written agreements where the parties have separated, etc. And your cases give you the rules on those. And once again, this topic could come up as an evaluative essay, or it could be a scenario where you've got characters and you've got to advise whether they're meeting intention to create legal relations requirements. Our next topic then is privity of contract. Now, privity is a fundamental principle in contract law, meaning that in general, only the parties to a contract can enforce its terms. A third party cannot enforce the terms of a contract that it's not privy to, save in exceptional cases. Now, this particular topic does lend itself quite nicely to an evaluative essay type question, where they ask you whether the rules on privity of contract are fair or not. But of course, the issues, the rules that come up in it can also appear in scenarios too, so you need to prepare for both. Looking at privity, always start with your general rule, and the general rule at common law states that a contract creates rights and obligations only as between the parties to such a contract. And key cases on this are Tweddle and Atkinson and Dunlop and Selfridge. Over the years, this rule has been very difficult and has posed lots of problems for the courts, so lots of exceptions to the general rule on privity have developed. Goods lost at sea, statutory exception if specifically mentioned or confers a benefit, other statutory exceptions such as the Married Women's Property Act, collateral contracts, agency, and trusts. To our next area then, and you can see from this slide that I've got express and implied terms and exclusion clauses on the same slide. Sometimes these are dealt with as separate topics, but to be honest, they're so closely related, and they will often, well, you can't really have one without the other in a scenario, so I've dealt with them together here. So in terms of express and implied terms, know the difference between the two. So express terms are those specifically agreed by the parties, and they can include pre-contract statements that are treated as terms rather than mere representations. And implied terms are those which haven't actually been included in the contract, and the parties may not have considered them at all, but nonetheless, the law says they're part of your contract, regardless of whether you wanted them or thought about them at all. So the first thing you need to be able to do is differentiate between whether a statement is a representation or a term. And you need to look at factors such as the importance of the statement, the knowledge and skill of the person making the statement, when it was made, and whether it's been made in writing or not. In terms of implied terms, you need to know when is it that the court is going to incorporate these terms that haven't been considered by the parties. And we've got a couple of situations here that you need to know. Terms implied by fact, terms implied by fact, the officious bystander, terms implied by fact, the business efficacy test from Moorcock, and terms implied by law. And you can use any example here. I've used the Consumer Rights Act 2015. So an example would be that all consumer contracts include an implied term that the item will be fit for purpose under Section 9. Exclusion clauses then seek to exclude or limit liability under the contract. And for this area, you need to make sure that you can discuss whether an exclusion clause has been validly incorporated into the contract. And you've got some key cases like Lestrange, signature, let the buyer beware, and other cases that you'll be familiar with involving hotels and car parking tickets that all come down to whether the claimant was given sufficient notice of the term. Next topic then, misrepresentation and economic duress. Again, you will have studied these probably as separate topics, but I've put them together because again, they quite frequently come up together in a scenario question. So for misrepresentation, you need to know your rules, that there must first be a false statement of fact, which induces the other party to enter the contract. And you need to be able to determine whether that statement was fraudulent, negligent, or innocent, because that's going to affect, that classification is going to affect what remedies you can get for the representation. For economic duress, you need to know the rules on duress, and I've put the key cases on the slide for you. Discharge of contract is a topic which wants you to discuss the different ways that contracts can be discharged. And again, you might have a number of these cropping up in a scenario. Discharge by performance and the rules on that. Discharge by breach, including actual and anticipatory. By agreement, and this one which does appear in scenarios quite often, discharge by frustration. And this one was actually on a scenario question for Educas last summer. And it wanted you to discuss whether a contract had possibly been frustrated by impossibility, Taylor and Caldwell being your classic case. Final topic in contract law is the remedies that are available to your claimant. And you need to be able to discuss the common law remedy of damages, including non-pecuniary and pecuniary loss. but also equitable remedies that might be awarded by the court, such as injunctions, specific performance, rescission,